striving to provide the best care possible. Introducing the Clinical Care Platform, a proudly South African, wholly owned online subscription edutech company built for healthcare professionals. Our mission is simple: to improve patient care by increasing access to high-quality, evidence-based educational resources, anywhere, anytime. With our membership subscription, you gain unlimited access to a growing library of over 155 CPD-accredited courses, weekly micro-lessons, and 10% discount on paid e-learning courses, all curated to align with local and global guidelines. Join live webinars, over 160 sessions and counting, earn CPD points on your schedule, and download key clinical resources, including templates, research reports, and practice guidelines. Subscribe, get educated, earn CPD points. With the Clinical Care Platform, lifelong learning is just a click away.
Missed our latest webinar? No worries. We know life gets busy, but your professional development shouldn't have to wait. That's why we've created webinar micro lessons. Short, focused recaps of our full sessions designed to help you catch up quickly and still earn your CPD points. These bite-sized lessons are available exclusively to active subscribe members. So even if you miss a live session, you never miss out on the knowledge or the CPD points. Not subscribed yet? Now's the perfect time to join. Get access to all future webinars, every micro lesson and more. Visit www.clinicalcareplatform.com to sign up.
My name is Dr. White. I'm an independent practitioner, and I'm here to share about my experience with CCP. I was introduced into a new and dynamic way of learning. The sessions were interactive and practical. The educators and instructors were easy to approach, easy to ask questions, making the whole experience much more enjoyable. In 2024, I enrolled into the HIV Diploma Preparatory Program, and I am now proud to announce that I have attained the diploma in HIV management. And not only just that, I passed with a distinction with the help of this amazing platform. I'm here today to express my deep appreciation for the effort and the time that has been invested in preparing these learning sessions from us. You sacrifice time away from your families after long work days to give 1-hour sessions, sometimes 2-hour sessions, and the time that you spend preparing for them as well. You are working towards creating a generation of knowledgeable doctors and specialists, not only in South Africa, but all over the world. The skills that we gain from tuning into your sessions, sometimes attending the live sessions, have also improved patient care and patient outcomes and have been a big contributor. Your work is extraordinary, and I'm here to express our gratitude as your receivers. And I pray that you continue to receive the strength to continue and carry this mission forward.
Because they are the ones that clip, you know, the ones that have the end that clips. You don't want that. It's a lot more difficult. Yes, it locks. It's a lot more difficult because now the procedure depends on you separating these two, putting them back together and separating them again. You want that process to be as seamless as possible. So you need a 10cc syringe, and that's sterile. The black needle is 22 gauge, and they need to be at least 30 millimeters. So these are 5 or 25. This is 32. This is 32 millimeters. So you need to ensure that you have the correct level.
But the weight muscle, like I said earlier, is difficult to biopsy. It's harder, so you can say you might not be seeing a lot of cells there. But this would be sufficient in this particular context. Then the reports will become as like a spindle cell lesion, formal core biopsy would be advised, because it's difficult on cytology to actually just tell in what cases what is the type of respiratory cell lesion, especially if you don't have access to ancillary testing.
Yeah, this one I'm seeing is like VCV malaria parasites.
It looks like malaria parasites.
Yeah.
Yeah, those are spindle cells of the mass.
Is it? Yeah, the tip.
Yes. Okay.
Finally, colleagues, good evening. Welcome to the clinical care platform. I feel you're like, hey, let's start. Where's Dr. Mawela? Well, I'm here. I didn't want you to miss out on some of the key updates. I hope you have enjoyed those videos, sharing with you what's coming ahead. Next month is not very far. We are a couple of days away, and we will be launching our diploma preparatory programs. So if you are still planning to write your exam next year, the coaching programs are ready for you. And last year we had the palpation fine needle aspiration workshop in Johannesburg. This year we are bringing it to KZN. So if you are a Durbanite or a KwaZulu Natal person, show us a thumbs up and say yay. I mean, it's not going to be virtual. I'm so excited that I'm going to be meeting some of you in person. So yeah, a warm welcome to you this evening. It's such a great honor as always to host you. This is our first evening official webinar for this week. So I was very excited during the day saying, yes, Chaisas Katsini, so that I can connect with my colleagues, which I treasure so much. I am not alone today. I am with Mto Mapumulo. Hi, Mto. Are you able to hear me? At least if you say hi to the colleagues, I want them to hear your voice. And then we will come back and introduce you again officially. Welcome, brother.
Good evening, Doc. Good evening to everyone. I hope you guys can hear me.
Yes, loud and clear. Thank you so much. We are so happy to host you and to welcome you to your new home, the clinical care platform. Colleagues, it's the first time we host him tour. You know how we welcome people so that they do visit us again. Can you please send him all those hearts, beautiful hearts and hugs? Just to say welcome. So I'm hoping you can see all the hearts heading your way. We like mixing it with a little bit of fun. So yeah, let me share my couple of slides and not delay you guys any longer. I want to remove one of these name tags. Give me a couple of seconds. Yes, I think I've managed to do so. So yeah, hey, I have so many things here. Give me a few seconds, colleagues. My screen is like, it has like 10 different windows. And I know I've got other people who are just joining us via the socials there. So I also want them to see some of the stuff. Yeah, okay, I think we are good. Yeah, so today we are discussing civil summons as part of our clinical governance and ethics seminars, and we are going to discuss what must you do when you receive a summons, things that I avoid, and I keep them there in the corner until it's the last minute that I realize I'm in trouble. I should have just dealt with it as it comes. So I'm hoping that today Umto will encourage us to do the right thing. Warrant of arrest, or a complaint from the HPCSA. So these are things that at some point in our careers we do go through, and they can only help us to become better clinicians. So don't be shy, but it's aligned with how we want to improve patient care. Yes, we want you to be a great clinician, but the way you provide the care, but also how you take care of yourself when you face these challenges is very, very important. So I'm so excited about tonight's topic. Just to remind you, if you are joining us for the first time, the Clinical Care Platform is a member-based platform. Please do visit our website, get membership, so that in addition to enjoying the educational content you're going to get today, You can also get your CPDs, your certificates, and we help you to comply and also get discounts for some of our paid events like the master classes, etc., etc. We want to really continue to celebrate having issued over 120,000 credentials to yourselves, particularly our members. We thank you for collaborating with us, but also our collaborators like Umto, because it's a platform. Those who love to teach and those who are hungry for knowledge, we give the audience that opportunity to connect here at the platform. Yes, just visit our website, and the team, they've told me today that they've added a second option to subscribe, which is a monthly subscription. I no longer have control over CCP colleagues. There's those young people who are doing their own things. They told me that you guys are complaining that no, 3 rand per day is a lot. You want to pay 3 rand per day every month. I'm like, okay, let me see what happens. But it only means that it's growth. If you are running anything, at some point you want to make sure that it can be alive without you. And yes, our diploma preparatory programs are going live in October. If you are writing or you want to master the art in HIV medicine, internal medicine, obstetrics, and child health, do visit our website, check out these programs, register, and get ready. We are launching 2 additional ones as part of this intake: diploma in anesthesiology and also ophthalmology, discussing issues of the eye. We can't wait, colleagues, to host you. You still have time because, we still have like 7 days or something before the coaching program start. If you are a late register, it's okay. We will welcome you. To our annual subscribers, not the monthly people, those who are paying 1,200 rands for the whole year, you now have an additional 10 micro lessons or CPD courses. So if you have missed any of these, just log in on the platform, enjoy your learning, care for your patients better. Don't worry about CPDs and stuff. CCP will take good care of you. We do have our paid e-learning courses, from the dispensing course to monitoring and evaluation. By the way, we have introduced, the team will announce, they told me today that they have put the maternity care guidelines. The maternity care guidelines, there are updated guidelines nationally. There is a course there. So just visit the Aqua page if you are a midwife or a doctor working in that space and you don't know the new guidelines. Everything from postpartum hemorrhage, antepartum hemorrhage, cord prolapse, and those kinds of things. Just go there and do your best. And also to remind you that this weekend we have Dr. Makake, our in-house dermatologist, and we are going to talk to issues of hair loss. Hair loss. Let me type the link there in the chat because I had copied it, but I forgot to post it. So I've just typed it there. Can I make a joke? All the ladies, you have to join this one. I get ladies, you've been saying hairline, hairline, hairline. Maybe it's not hairline. Come and join us on Saturday and learn more if your problems are hairline issues or hair loss issues. So I'm expecting a lot of ladies. But if you're the guy, join for your wife, join for your sister, join for your mother, so that you can give them proper advice around why the hairline is busy going backwards. Ooh, I'm so sorry. I'm so sorry. Mushabi, our hairline gone yet again. So yeah, go. Yeah, please come and learn how to keep the line to where God wants it to be. The last event is the one that's happening on the 25th of October. I think I showed you the snapshots. These pictures are not from Google. It's the real one. You can see our clinician with Prof. Moshawa there from SMU. She's practicing how to do the FNA there using a chicken specimen. You're going to use a number of specimens to learn how to do those FNAs. So it's a real boot camp. So do join us in KZN there on the 25th. But today, it's not about me. It's such a great honor to host Umto Mapumulo. He's an admitted attorney and partner at Adams and Adams, and we're going to be thinking about what to do when you are challenged with the legal issues in this space. But just to read a bit about Umto, because it's the first time we host him. I won't read everything, but there are key things that are important that I want you to know about him. Number one, he graduated at the University of KZN. So it means you'll join us for the FNA. And with several distinctions. He doesn't want to tell us how many. So he's a real gem. Academic awards, but also he's got the dean's commendations. I mean, this is not small things, right? So during this period, he also served active leadership roles in many student organizations, including the Black Lawyers Association student chapter, Students for Law and Social Justice, and upon completion of his LLB degree, he joined Adams and Adams, straight to Adams and Adams, wherein he served in his two years in articles. He's currently a partner in the dispute resolution department. So if there's a dispute, send him a WhatsApp with specific focus on insurance and financial sector law matters. He's a partner as well in the insurance department in the firm where he represents internationally renowned insurance companies, underwriters, intermediary firms, corporate institutions, and individuals. And he represents, litigates, and advises clients on broad spectrum of insurance and financial sector laws. He further does extensive regulatory work for financial service providers. And I want to close with the last paragraph there, that he's got extensive litigation experience, having previously been in the personal injury department. In this area, he dealt with personal injury related matters, including product liability, medical law, slip and fall. These are our issues in healthcare. Wrongful arrest, unlawful detention, professional indemnity. That's another issue in the healthcare space. RAF, PRASA, etc., etc. So he's got a vast experience in the legal field, but you can see that he might not tell us, but you can see that he's quite a smart person. So we are so happy, to get you on board. I like that you have this leadership journey. I really love issues around leadership. So we just want to say thank you again for having made time to join us this evening. To, can I hand over to you to share your slides and then maybe your opening remarks to the colleagues? Colleagues, we did try to get Mto's video to work. If it doesn't work, in the poster there was his picture, but if it does work, you'll see him. But otherwise, we are happy to be empowered. Thanks a lot, Mto, our attorney for the night.
A good evening once more. Thank you very much. Thanks for that lovely introduction. I think it does help if it's visual, because when it's in person and your profile is being read out, you kind of stand there with a little bit of shyness in your face. So I think it's better if it's online, like we are having it currently. Thank you, Doc, and thank you to all the attendees and the family that has joined this evening. I'm quite surprised, I must say. Well, firstly, it's obviously my first time on this platform, but I didn't expect we will have so many attendees online, particularly because tomorrow it's a public holiday. So I thought people may be traveling, people may be out and all.
Sorry for the disturbance.
Thank you. Yeah, no. But I must say, you know, when you speak to the audience in such kind of a scenario where people could have decided to do other things, you are kind of encouraged, because you know you are dealing with people that want to be here. So it's not people just adding numbers. So thank you very much. Without any further delays, I think the introduction that you have relayed was spot on, and it covered basically everything. So I do not deem it necessary for me to really say anything further, except to just reaffirm that I am a partner in the insurance department at Adams and Adams. And I graduated at UKZN with my first degree. Then I recently got my LLM in insurance law and governance at UP. So I think that suffices as part of an introduction. Okay. And I'm not sure how you usually do or go about comments, questions during such presentations, but I'm very happy to take comments, or rather to listen to comments and take questions during the presentation itself. Maybe Doc, you can just tell us how we should go about that part in terms of comments and questions.
No problem. We'll go through all of them at the end. Thanks. At the end of the presentation.
Okay.
Thank you. Sure.
Okay, thanks a lot. Okay. You will just forgive me if some of the things I touch on are too basic, but I sometimes I'm always very wary to assume people do know some of the things that some people may deem to be common knowledge or too simple, but so you will just bear with me in that regard, because I try to at least ensure that we are all in this room, we are all at the same level, and we are at the same on the same page in terms of what we are really discussing. Okay. Let us maybe start looking at letter of demand and or summons. Okay. So I must just emphasize to say that whatever that we are going to be covering today is things that I deal with on a daily basis, because as part of our insurance work, and the vast bulk of our work actually is professional indemnity, and most of those, for some reason, it's doctors. And by no means am I suggesting, or that means that doctors commit negligence all that much. But the reality is, even if you go to court, you will realize on the court rolls that most of the cases, professionals who are being sued mainly are the doctors or medical practitioners rather. Okay. In terms of the definitions, the first one is letter of demand. So what is a letter of demand? It's a formal request for payment or action, which ordinarily a precursor to litigation. So it's very important. You will see when I touch on the second column there being process overview, I will just explain a bit more with respect to the letter of demand. So at this stage, you should just know that a demand will be a letter that requires you to make some payment, pay some compensation, or undertake a certain action. Okay. And this letter ordinarily results in an official court proceedings. So once you've received a letter of demand, lawyers would give you 5, 10, 14 days to comply with the request or the demand, failing which they will very expressly state that they will proceed with the court proceedings. And that is when then summons comes in. So a summons is an official document which commences legal proceedings, and I specifically say there it commences civil case, because criminal cases are dealt with in a slightly different manner, and we will very briefly get to that when we talk about criminal charges against medical practitioners. Okay. So your letter of demand, it should always, in your mind, when you are being served with a letter of demand, it should flag for you that an official litigation or civil proceedings are looming. Okay. Then why is it important to understand the definitions of letter of demand and summons? It is because your professional indemnity cover specifically requires you to act in terms of the policy when you receive these documents. Okay, so when you receive a letter of demand, that ordinarily constitute what is defined as a claim in your policy. So that means you need to inform your insurer immediately when you receive a letter of demand. You do not wait until a summons is served on you or at your practice. And trust me, the number of matters that we deal with, be it HPCSA complaints, be it litigation, we find that most of the medical practitioners, the practices and different practitioners, they do not report, they do not inform their insurers when they receive letters of demand. This is either one, possibly because they do not deem that to be something really of serious concern, or rather that is required in terms of the policy, or it's just the staff of the practice not being informed or educated enough about these things. Sometimes when the sheriff serves this letter, they may just leave it by the receptionist, or they may, or some assistant. Sometimes the personnel in the practice do not immediately bring this to the attention of the person in charge of the practice or the practitioner. So it is quite important that we also just educate and inform our staff when it comes to these things. And the one thing that we always sit with when we advise insurers, we would say, sorry, just a step back. So professionals or practitioners will not inform the insurers of the letter of demand, but they always or almost always inform the insurers when a summons is served. And at that stage, it may be maybe 20 days later or 30 days later. And when we give advice to the insurer, we say to the insurer, in terms of the policy, you are actually within your right to decline or reject this claim. But what we always try to do, because obviously we do accept that most of the medical practitioners are not legally trained. They have no background in law. We kind of persuade or suggest to the insurer to say, be that as it may, and be that as a breach of a requirement or condition of the policy, we believe that there's been no prejudice on your behalf, and we would suggest that you rather entertain and assist the insured being either your practice or you specifically as in your capacity as a practitioner. Sorry. But strictly speaking, the insurer is well within its right to decline your claim if you do not inform or provide the letter of demand to them immediately upon receipt. And you can accept, there are many reasons why the insurer wants you to immediately report. Many reasons. For example, there is, the sooner they get to know about it, the sooner they can either instruct their legal team to respond comprehensively to the letter of demand, which in most instances we do for the insurers, and we find that the claimant or a plaintiff, a plaintiff being someone that is suing, they will be dissuaded from pursuing that action any further. So it's very important. So reporting immediately is very important for that reason, because the sooner the insurer knows, the quicker they can set some wheels on motion or in motion rather, to go about safeguarding the rights of, well, your rights as a medical practitioner or a practice. So similarly, when you receive a summons, you do not ignore the deadlines. You immediately inform your insurer, and your insurer will either respond directly to a letter of demand. Well, insurers do not respond directly to the summons. They would involve us as attorneys to assist in terms of responding to that. And what we normally do, and this is one other benefit of reporting immediately to your insurer, we would normally be in a position to very quickly assess the merits to see whether the claimant in that case really has any merit. You will be surprised at the things that people nowadays sue for. I mean, people sue for the most ridiculous things, to be honest. And if you inform your insurer sooner, we are able to very quickly respond comprehensively and lay out legal basis why they will not come right or succeed, or rather succeed in their pursuit of the legal action. Then, then at that stage already you can put a stop to any threat of legal action. Then my practical tips, which I think I've overly emphasized on this slide, is to say, importantly, never admit liability or respond directly to the claimant. If you do that, you risk prejudicing your rights and your insurer's right. But at the same time, you also risk it's not inflating, but you also risk making the facts of the case more complex by subsequent actions. And you try to avoid that by all means, okay? Then this is very important. Try not to prepare your own plea. Just briefly, I will elaborate on that. A plea is is basically a response to a summons. It's just that in the legal terms, it's called a plea. That's where you put up your defense, okay? And you may read through some of the summons. When you receive a summons, you can read through it and you will see the allegations. So the claimant will say, they attended to your practice on this day at this time, and there was an oral, partially written contract between himself or herself and yourself, or the practice, and you were under a legal duty of care. You had to follow these steps. You were negligent in not doing A, B, C, and D. And when you read that, I mean, any person can read that. But when you have to respond to those allegations, there are specific legal technicalities that, unless you possess some sort of legal background or legal knowledge, particularly in civil procedure, not just any other sort of legal background, you will really get yourself in trouble, because you may respond to these allegations, but on the technicalities, they are not compliant with the rules of court, with either. Also, it's possible that they do not align with the practice directive of that particular court. Then you are actually now prejudicing yourself in that instance, because you allow the claimant to take what we call an exception, whereby they apply to court and say, it's not an exception per se, but they can say there is no proper defense that has been raised here, and they say it goes with vexatiousness, and they say there's no defense that has been taken, and they may actually put it up on an application. Well, they can bring an application called summary judgment, and they say you do not have a defense. You are just defending this, or trying to defend this for your own selfish interest, to put it plainly. And it gets very, very, very complex now, because when you go through that application process, you only have a once-off opportunity to defend this. You need to be able to really be able to put up a very, very strong defense. So you try to avoid and nullify those possibilities or chances by ensuring that you do not try and prepare your own plea. I mean, you rather, if you do not have an insurance or PI cover, you rather appoint an attorney and you finance that litigation on that basis. Okay. I think that suffices. We can move over to the HPCSA complaints. Okay. We do get we do deal with these quite often as well. You get some of the most ridiculous complaints that patients bring against their erstwhile, or even sometimes practitioners that they still go to them for medical assistance, which is quite ironic. So we do find these quite often. So just briefly there on the nature of these complaints. These can relate to an alleged professional misconduct, negligence, or unethical behavior. Sometimes it's a combination. It's a combination, for example, of professional misconduct and professional negligence. Okay, so it really depends on what is the nature of the what is the basis of the complaint, what it is that the patient is complaining about. Okay. Then just briefly on the process overview, you as the practitioner, you are notified of the complaint by the HPCSA. Well, this would obviously be in writing, so the HPCSA would prepare a very nice letter that states when you should respond. They do not really go much in terms of the details of the complaint, and the reason for that is because they provide all the documents and the information that the patient submits to them. So they would just do a very brief letter to you, and they attach all the documents and the information that the complainant, being your patient, submitted to them. Okay. And again, with this, you need to inform your insurers immediately and provide them with whatever documents that you may have received from the HPCSA, together with, it does help if you are actually going to also provide your draft response to the allegations or the complaints to your insurer immediately, because you then allow your insurer to immediately involve an attorney, and the attorney really then has some sort of an idea as to where you stand, or rather what is your position in relation to the allegations and the complaints made against you. Okay. So when you receive this, you as the practitioner, you obviously need to submit a written response, and well, it's basically always within a set time frame. In this regard, by reporting this to your insurer, you take away, one, the need to really be worried all the time about this written response that you need to submit to the HPCSA. And let me just share this. The HPCSA complaints, they are so restricted or limited in, or rather, the HPCSA as a regulatory body is so limited when it comes to such complaints, in that they, for example, cannot deal with instances where your erstwhile patient wants to recover monies back or something like that, or the complainant wants to be compensated with some some monetary compensation. So I mean, if you get an attorney or even your insurer, they can actually just say this falls beyond the four corners of the HPCSA's mandate. And that can really be your response to the HPCSA complaint. And you, well, although risky, I still try to go into the actual facts and the merit of the complaint, because you do not want someone at the HPCSA saying, well, sorry, it does actually fall under our mandate. But there are clear instances where you really do not need to go much in detail in relation to the facts and the circumstances of the complaint, because it falls beyond the perimeters of the HPCSA mandate. Okay, so it's quite important that you either inform your insurer or you appoint a legal practitioner that is clued up with HPCSA complaints. Okay. Then the preliminary inquiry, the HPCSA may request further information or refer the matter to a professional board. So once you've submitted your written response to the HPCSA, and depending on the nature of the professional misconduct or negligence or unethical behavior in question, you may, the HPCSA may just read your response and say, well, you've been able to rebut all the allegations and all the complaints against you. Then they just say, well, there is no need to take this further, and you are cleared on that basis. Or they may say, well, you actually need to either in the form of an informal resolution, whereby there would be some sort of an informal mediation between you and the complainant, and there can be some sort of explanations that are given orally, ordinarily in person, and you try to amicably resolve the dispute. Sometimes it really is misunderstanding between your erstwhile patient and the procedures that had to take place, and you are able to explain to them again in the presence of a mediator, and you are able to resolve the matter on that basis. But I must say, most of the complainants, being your erstwhile patients, they always really feel aggrieved, and they want something more biting than just an informal resolution on a mediation platform. But I mean, I think that's just human nature. You want a little bit of punishment, so to speak, when you are in such situations. Or in more of serious breaches of ethical rules, or some serious negligence or serious professional misconduct, the HPCSA may say we need a formal hearing, and this is where it's more of those who've been in an arbitration kind of a setup, that it mirrors that process quite closely, because then at that platform, at a formal inquiry, you as the medical practitioner, you are within your rights to come with your legal team, and they can represent you as they would do, either be it in court or in an arbitration. So it is quite important that important to always know whether you are going for informal resolution or a formal inquiry, because you may just be prejudiced if you just appear by yourself at a formal inquiry, because the board there may have obviously there are some legalities or legalese at play when it comes to such complaints. So for me, it is always advisable to have your interest safeguarded appropriately. Okay. Then on the practical tips, quickly, I say please ensure that you respond promptly and factually to the complaints. Ensure that you notify your insurer immediately where applicable. And if you do not have an insurer, or you have a PI cover, but you do not, you do not enjoy protection for HPCSA complaints, which is quite often actually, you need to ensure that you appoint your attorneys to assist you with the complaints. And I may just add there to say it may be worth your while to either confirm with your broker, or you check your own policy whether you do have HPCSA, your HPCSA extension on your policy. Then we say again, do not contact complainants directly because you are just causing more troubles if you do that. And we say seek legal advice before submitting a response. Okay. I will go through this one quickly because this is now for the nurses, obviously. But the process to the greatest extent mirrors the HPCSA process. So similar to the HPCSA, but specific to nursing practice, it can involve individuals or groups under a scheme. Then also when it comes to the process overview, it's a written notice of complaint. You need to respond in writing as well. Then the South African Nursing Council may investigate or call for a hearing. And in terms of the possible outcomes in such situations or such complaints, it can be a dismissal, it can be warning, and it can be a disciplinary action. And I must say it can get very tricky with the nurses actually when it comes to this, because in most instances, it ends up being labor issues. It ends up being a labor issue, and it can get a little bit complex. And I think that whole discussion would require a whole session on its, in itself rather. So yeah, because there are so many things that nurses require certain approvals when they deal with on a day-to-day. And sometimes the line may be very blurred as to whether certain actions needed certain approvals, certain approvals from someone higher than that specific nurse. And when it comes to possible outcomes, in case of a dismissal, in case of a warning or something severe in nature, in terms of the outcomes, it can get very tricky, because you as a practice or as a hospital, sometimes you do run a risk of having to go through the labor process, or sometimes CCMA and all those kinds of channels. Okay. So very briefly on practical tips: you follow internal protocols for notification, you cooperate fully, but you do not admit liability, and you engage your insurer and legal team early. I think I forgot to include the not admitting liability part when we were talking about the HPCSA complaints. And we will still very briefly also touch on some of the investigations by the medical schemes. I know sometimes, and I'm now talking about, I'm not going to obviously share the details of the doctor or anything like that, or the practice, but we are sitting with one matter where the doctor, as a matter of convenience and also for practical reasons, she just decided to when there was an investigation to admit liability in the sense that she signed an acknowledgement of debt. Well, one, because she wanted to well, it's a matter of convenience again, in the sense that she wanted to pay back whatever the scheme wanted back, so that she could be able to get payments from the scheme going forward. Only for the scheme to refer the issue to or the breaches and the liability that's now been admitted to the HPCSA. So it complicates it a bit, because now you go to the HPCSA, you're already on the back foot because you've admitted liability. There may have been breaches, but you are you are at a better position without admitting anything. So rather get proper advice before you admit wrongdoing or certain breaches, especially when it speaks to ethical conduct. It speaks to to the regulations. It's quite important to ensure that you do not admit liability, even more so when it comes to claims of negligence, because yeah, there may be serious consequences for those. Then on this being now the criminal charges against doctors, these are quite tricky, and yeah, these are more serious. These are much more serious, and it can things can go south if they are not handled appropriately from the inception. Okay. So very briefly, in looking at nature of charges that doctors may face, the most obvious one being murder. This in practice is a bit tricky with a charge of murder, because it requires proof of intent, being an intention. I just added there to say in the form of dolus directus or dolus eventualis, but I'm not going to bore you with the legal technicalities and requirements relating to those. I think it does suffice to say that the state, when you are being charged with with a charge of murder, then they will have to prove intention, which is very difficult in practice, particularly in the context of medical services. So yeah. But what is not so difficult, or less trickier, maybe I should say it, or put it that way, less complex, is to prove negligence. And therefore, what the state would do is they would lay charges for murder, and they would also, as a second charge, a competent verdict. I think that's what it's being referred to in the criminal law space. They would say, should they not be able to prove murder, then you are guilty of culpable homicide. And there it's a bit tricky, because the standard of proof is not as high. With murder, they need to prove intention, and that's very difficult. But with culpable homicide, they only need to prove negligence, which is not so difficult to prove in practice. Then sometimes you also have fraud. These obviously need to be done for beneficial gain under false pretenses. Fraud also is not so is difficult in practice, because there you also need to prove intention, but it's not all that difficult. The same similar to murder. To murder, because lots of financial documentation can ordinarily be enough to prove intention when we are dealing with fraud. So yeah, I think those are really the three main kind of charges that doctors run risk of facing. Okay, then I just added there to say, in practice, murder charges are rare, unless there is evidence of reckless disregard or intentional harm. Most cases are prosecuted as culpable homicide due to negligence. Okay. And briefly on the procedure well, when you are faced with criminal charges, the following procedure would ordinarily unfold in terms of the Criminal Procedure Act. The arrest may be made with or without a warrant. Well, maybe some of you may ask, under what circumstances would it be justifiable or be warranted for a medical practitioner to be arrested without a warrant? Those would be, for example, instances where the crime in question is quite serious. So in these instances, I think if fraud is one of the charges that being brought forward, I mean, there is quite seriousness in terms of the nature of the crime that we are dealing with, because for you to have committed fraud, it would have required a lot of effort in terms of planning and carrying out your modus operandi to commit that kind of crime. But also in instances where there is a risk that evidence may be destroyed or may be lost, then being arrested without a warrant may be justifiable. Again, I think fraud is a very good example here, because there may be certain financial statements, there may be certain bank information or access to certain accounts that needs to be blocked or to be frozen immediately, and in fear that you may take steps to interfere with that kind of evidence. The state, or rather the police, is well within their right to arrest you without a warranty. And sometimes it could be so serious that there is a risk that you, as a suspect, you may evade arrest. And in that instance, the police cannot delay your arrest and they can just proceed without a warrant of arrest. Okay. But I think it's important that I add to say that being arrested without, a warrant of arrest is an exception than a norm. So ordinarily, the police must produce a warrant of arrest. But, particularly, I think in most instances pertaining to professionals like medical professionals, I think in very, very, very rare instances will you find any justification, legally speaking, to make an arrest without a warranty. Okay. Then the accused must be informed of the reason for arrest and given a copy of the warrant if applicable. Okay, so you need to know why you are being arrested, and you need to be brought before a court within 48 hours. Yes, sir. It's so often that that you encounter now in the legal space, one encounters lots of unlawful arrest or malicious prosecution cases, due to failure to bring the accused before court within 48 hours. So the law requires you to be brought before or rather within 48 hours. But in practice, somehow there are things that just go south when it comes to that. Maybe quickly on the do's when you being arrested, you need to immediately contact a lawyer experienced in criminal law. First, I think I think a criminal lawyer is probably your most important one in terms of the levels of importance. When it comes to these, you need to get your criminal lawyer contacted, and they can guide you, particularly when it comes to procedure, because procedure in criminal cases is very important. Then, obviously, in terms of the levels of importance, your medical malpractice specialist or lawyer specialist becomes very important. So you need to ensure that you safeguard your interest by obviously informing your lawyer, and I would say you prioritize your criminal lawyer or medical malpractice lawyer as your second most important legal mind in that instance. You need to document everything. Practically, it's not always possible, okay? But insofar as it is possible, you need to keep detailed records of patient interactions, procedures, and decisions. These become part of your evidence when it comes to court. Then we say request expert assessors. So that is basically saying that you need to get an expert to come testify in court and be able to assist the court in the determination of your negligence, whether or not you were negligent in carrying out your instructions. Well, it's not instructions, but carrying out your duties. That's the right term. Yes, duties. Then sometimes the processes may run parallel. So you get your HPCSA complaint for a specific incident or treatment to a particular patient, but at the same time there are criminal processes or criminal charges pertaining to the very same incident. In that case, you cannot pick and choose which one to entertain, which one to prioritize. Unfortunately, you need to ensure that you engage with the HPCSA in that instance, and at the very same time, you give your full attention to your criminal matter as well. So I know the repercussions for your criminal charges are much more severe than the HPCSA complaint, but it is very, very important to ensure that none of the processes receive less attention over the other, because that just speaks to the professional the professionalism and the standard that is expected of professionals like yourselves. Then we say, where possible, even when it comes to, regardless really of the charges and regardless of the platform or forum where you are facing some sort of explanation that needs to be done, or facing a complaint rather, you always, it's always very helpful to consider mediation. And that would ordinarily be in your civil cases. I just added it here because I think it's still worth, it's worth a mention to say that before you really litigate, and especially if you do not have an insurance cover in place, or your claim has been rejected somehow, it's very important to try and you amicably resolve the dispute. Sometimes, even in that instance, you rather, if on the merits you are liable in the sense that you are negligent, or rather you were negligent in carrying out your duties, and your negligence caused harm of some sort to the patient, it's very important that you do not run litigation unnecessarily. Well, that is what we even with the insurers, that is the stance that we take. You do not blindly litigate. You litigate if there is a very good reason for litigating. Otherwise, you just try and mediate, and you can actually end up having to pay very little in litigation if you just go through the mediation route. And sometimes there's no particular wrongdoing on the part of the practitioner, but it's just some sort of misunderstanding that requires a more organized and coordinated ventilation before a mediator or an impartial mind. And that does save a lot of time and lots of money in the process. Okay. Then the don'ts: when you are faced with criminal charges, you do not speak to police or investigators without legal representation. It can be very difficult in practice, but please try not to. If you have to speak, do not say too much. Just don't say too much. Avoid making admissions or apologies outside of protected mediation settings. Do not destroy or alter medical records. Avoid defensive medicine, unnecessary tests and treatments, and treatments to avoid liability, as it may be seen as unethical. Okay. Now, what to say? These you can say. I mean, this is not a closed or exhaustive list of things to say. It's quite a few, but say these things. Try to remember saying these things. I wish to exercise my right to remain silent. I would like to speak to my lawyer. That's very important. That's very, very important. That's very important. I think I cannot emphasize that enough. And it's important that you say, I do not consent to any searches or questioning without legal counsel. The good thing is, if you say these things and the police or the investigators do not respect these, they become very important in terms of the procedure. So in terms of the Criminal Procedure Act, I mean, it's there in the name of the act itself, criminal procedure. So there are specific procedures, and where they breached, or there's been failures or refusal to follow those procedures, it can have very favorable outcomes for you as an accused when it comes to trial, because you may have made certain admissions without having your lawyer around, in instances where you had wished or expressed a wish to exercise your right to remain silent, but they forced you to speak up in the absence of your lawyer. Then in that instance, that will become very important when it comes to court. I mean, in the criminal proceedings, you may be able to escape any imprisonment or any criminal penalty on the basis that the procedure was not followed. So it's quite important that you set these out when you are being arrested. I do hope, obviously, none of us on the platform gets arrested, but if in a very, very unfortunate event or instance, please ensure that you do say those things, okay? Then I then just add there to say, these statements protect your constitutional rights and prevent self-incrimination, okay? Moving over, I think that we are approaching the end of the criminal charges slide. Then in terms of what not to say, do not try to explain or justify your medical decisions during arrest. I mean, the men and women that are carrying out the arrest are police. And regardless of how much medical, I mean, even if it was just a lawyer like myself, if I were to carry out that arrest, it really would not matter how much explanation you provide to me. I would not be able to understand it. So rather you save your time and tell me more important things. Tell me about wanting to speak to your lawyer. Tell me about wanting to exercise your right to keep quiet or do not speak. I would rather hear those things than trying to explain medical terms. I'm very, very bad with those, and I would like to think most police as well, with all due respect, they are in my position when it comes to that. Then we say, do not speculate about the patient's condition or cause of death, please. Do not admit fault or negligence. Do not discuss the case with colleagues, patients, or media. Shush. I cannot emphasize that media part. so much litigation is going on based on things shared on social media specifically. But I mean, it doesn't matter which which media platform it is, be it a social media platform, be a mainstream media, you do not discuss a case. Even if you want to drive a defensive approach or strategy of some sort by speaking to the media, just refrain from doing that. Unless you get a lawyer that says to you, do it for some strategy. But from where I am, and my advice to you as we sit here, it would be to say you do not do it. You do not do it because, I mean, even on the mainstream media platforms, they would take your story. They would not necessarily change the substance of what's being said, or rather of what you relayed, but the reporting style can just dilute the actual message that you wanted to carry out. So my advice is you stay away, just keep quiet. Okay. Then practical tips for defense strategy. Okay, so now this would obviously be after the arrest and after all the criminal technicalities have taken place in terms of the arrest, bail, hearings, and all those kinds of things. Now you in the main trial, you are in court, you need to produce evidence. Now, in terms of the levels of importance that I spoke about in relation to the lawyers, now your medical malpractice lawyer becomes probably the most important when it comes to the actual trial, or when we are dealing with evidence. I mean, the case stands or falls on expert evidence when it comes to these kinds of instances. So you need, so courts will rely very heavily on expert medical opinions. So lack of expert evidence can be detrimental. So judges, they are not very much different from myself and men and women in the police, in that we've got very little to no knowledge of medical field or medical profession. And when we are faced with cases, we rely on the experts to guide us. So this is why then your expert testimony is very important, because your expert is able to guide the court in a very slow and very simple manner, to very well, in layman's terms, to explain to the court the process that took place, how it should have taken place, and whether it did take place in the manner that it should have taken place. Depending on what the expert says, you may be found to be not guilty, or you may be found to have committed negligence, and therefore maybe you are you've got to be convicted for a charge of, say, culpable homicide. Okay. Then challenge procedural irregularities. If your rights, or rather your trial rights, are infringed, say unfair evidence admission, you can raise this. It's not on appeal, sorry, it should be review. There are some legal intricacies that draw a very clear distinction between an appeal and a review. So there it should have been a review, okay? So I think that is actually the point I touched on briefly, sorry, earlier, to say that you may be able to bring these procedural deficiencies or irregularities at the hearing of the actual case, and you may actually be exempt, or rather be found not guilty on the basis that there were breaches of in procedure. Okay. Then the court, well, sorry, you need to distinguish between error from negligence. Courts recognize that not all errors are negligent, and that is very important. I mean, there are certain risks in practice that kind of come as natural risk or risks, and therefore they are excused in law and they cannot constitute negligence per se. So mere judgment errors, particularly in emergencies, may not be criminal. Okay. And you need to make full use of your constitutional protections. When we speak about criminal charges, your section 35 of the Constitution is very, very important. And I mean, even beyond just your professional complaints or some sort of charges or criminal charges, it's very important that you maybe know what your rights are as a human being, as a citizen, or as a resident in the country, that you do understand what your Section 35 rights are. Because trust me, when it comes to the arrest, you may be arrested for things that you've got no business with, you've got no idea where it comes from, and you find yourself having to answer to some crimes that you've never been part of. So very important section. Okay. Then these are now your auditing dispute. I will go very quickly through these. So I think we touched very briefly earlier on these to say insurers or third parties may audit medical practices for compliance, billing, or quality assurance. We see medical schemes quite a lot. Well, at least from my space, I get quite a number of instructions where there are audits by the medical schemes. And this is where then your record keeping becomes extremely, extremely important, accurate record keeping. When I speak about records, I always try to say that the records or the contents of the records must also be equally accurate, and rather be overly detailed than being less detailed. It doesn't really help all that much to have very good record keeping systems if the contents of the records themselves are not all that helpful or detailed enough. Okay. So very briefly on the process, you would receive a written notice of audit, and it will ordinarily list a number of documents and certain information that the auditor requires from you. Then in preparation, you gather and review the requested records. And the audit process, the auditors may visit the practice or request electronic records. I must say, yes, some of the auditors or the investigators, I don't want to say lazy, but they are not all that proactive. They would not want to visit a practice because for me, I mean, even on many matters that I deal with beyond just medical negligence, it can be either public liability matter or anything like that. I do believe in visit of the actual site, in this instance, a practice, because I think it brings lots of perspective to you as, in this instance, an auditor, to see how things are run in that particular practice. But I recently dealt with one matter. Unfortunately, the lady was, she was running many practices at the same time and in many, many different provinces, or rather regions, I think. And so some of the practices, so she could not exercise full control and oversight of some of these practices. So now the record keeping and all those kinds of issues could not really be adequately be attended to. And unfortunately, when these audits come, they usually well, they will always go to the practitioner who is responsible for that practice. So the auditors would really care less about you running many practices. At the end of the day, you need to ensure that you've got sufficient and proper systems in place. And this lady had to pay back something very, very short from a million rand, unfortunately. Then the findings from the auditing dispute, a report may be issued, may result in recommendations. Ordinarily, it would be repayments and further action. And that further action is very important because once there's been an audit and there are certain breaches in terms of your record keeping, that would now be possibly and most likely rather breaches of the HPCSA regulations. And what these medical schemes, or let me not say these medical schemes, what the medical schemes then do, they then want to report that to the HPCSA or bring to the attention of the HPCSA to say that they've done this audit and this is what they've come up with, and they just let the HPCSA run their process. So you then deal with a complaint that, well, wherein there is an audit investigation that underlies it. So you now have to go and answer to the HPCSA for those breaches, etc. So the practical tips in this regard, you need to fully cooperate, and you do so transparently. You need to ensure all records are up to date and accurate. You need to consult with your insurer where you do have an insurer and ensure that such audits or rather your policy has that extension. You need to ensure that you do have that extension in your policy, and you need to understand your rights and obligations under the policy. Then general recommendations, you always need to notify your insurer promptly about any complaint, dispute, or legal process. You do not admit liability or attempt to settle without insurer involvement. I think I touched on this earlier to say we are currently sitting with one matter like that, where this practitioner, with all good intentions, she was just trying to be practical under the circumstances, particularly because the amount of money that she had to pay back to the scheme was very little. So for her, it was really a matter of convenience and a matter of practicality. So she just decided to sign an acknowledgement of debt, and then the scheme proceeded still to refer that or report that to the HPCSA. And I mean, we cannot fault the scheme in that instance because, strictly speaking, there is a breach, particularly because you've now admitted liability to that extent. So you try not to admit liability, okay? You need to ensure that you maintain comprehensive records and documentation in your practice, and you need to seek legal advice early in the process. Again, I think with respect to this last point, I did mention earlier on to say you need to educate staff on protocols for handling complaints and legal documents. I may just add, sometimes you do not get a letter of demand immediately, you do not get a summons, but and it does okay, rather a lot with hospitals, whereby it does also happen with like the individual practices, where your erstwhile patient lawyers request medical records pertaining to your treatment of that patient. And in those instances, if you do have a policy, PI policy, you need to inform your insurer, because in most of the policies, in terms of the definition, that would qualify as a circumstance. So there is a specific definition of what qualifies as a circumstance, and a request for your medical records would qualify as a circumstance. So you do need to report that. We once dealt with 2 matters pertaining to one medical practitioner, where the lawyers of this erstwhile patient of this practice were making calls, were writing emails, which landed before the receptionist of the practice. And for some reason, and I think it's a matter of being uninformed about such things. Well, for one of the matters, it was over a period of 2 years. There was just a chain approving these requests. Then I think for the other case, well, same doctor again, there was, it was just months less than a year in terms of the request. So it's very important that they are informed. And in that case, well, in those 2 instances, we did advise the insurer to say, in this case, in these cases, you are well within your rights to reject these claims, but we obviously motivated why maybe it is important. Well, it may just be a good thing to entertain the claim, and we would normally say to the insurer, well, it's easier to persuade the insurer to entertain the claim if the merits of the case are not strong. So you say to the insurer, rather you assist this practice or this medical practitioner because the claim itself, there's no sound or strong legal basis for it, so it is defendable. But I mean, the insurer may very well decide to reject, despite there being a strong defense, and they will very much, well, they would in that kind of a scenario be very much entitled to reject your claim. Okay. Then briefly, I must say these do not land before lawyers quite often, and these are billing disputes. And the reason why we do not find these a lot is because most policies do not cover this. I've never come across one policy that cover billing disputes. But the reality is you guys, or most of you, probably do face these kinds of disputes in practice. Well, the insurers may not always sell this kind of an extension or product, if I can call it that, but you, in any event, are within your rights to seek your own independent legal advice or legal team to assist you, particularly where we are dealing with huge sums, huge quantums in dispute. It may very well be sagacious to involve an attorney to assist you through the process. So just briefly, in the nature of the nature of these kinds of disputes, these would be the disagreements over fees, coding, or payment for services rendered, process overview, internal review. You need to check records, contracts, and billing codes. Engage with the other party. You try to resolve the dispute amicably. Well, then the mediation obviously is a neutral third-party mediation if you are unable to resolve the dispute directly with the other party. In terms of the escalation, how far this thing can go, and unless really warranted, and it's justifiable, legal action should be a last thing to really deal, or rather to resort to in these kinds of cases, unless obviously when we are dealing with huge sums of money that are in dispute. If I can then just briefly share the practical tips. Sorry, we will say you maintain clear, accurate records. You communicate professionally and document all interactions. You need to seek advice from professional associations if necessary. Okay. And that, ladies and gentlemen, brings us to an end of the presentation itself. But obviously, my understanding is that the platform is now open for questions, answers, and comments. Thank you very much.
Awesome. Yay. This was very empowering. I actually enjoyed the approach, Mto. I thought it was very good. The
Thank you.
nature, the process, and then I think the important parts, the do's and the don'ts. Colleagues, I hope you have noted some of this so that Umto in the future he can feel good that he has empowered us to be better prepared and not to rush. You know, sometimes I think there's two kinds of people. So there's those who are so quick to respond, and maybe there's a lot of mistakes that happen. Then there's
Yeah.
those who, I don't know, they freeze or something like that and wait for the last moment and then they call you. Because as you were presenting, I wanted to ask you, what are some of the beliefs? What is your understanding? Why do someone like me, particularly me, I would pack it. I can tell you, pack it and say, this thing, I'll deal with it. You know, until I feel okay. Now I feel like there's a lot of pressure, you know, to deal with it. And when I looked at what you presented, I might have missed opportunities to even deal with the issue so quickly. Do you understand the mental things that push us to not act on these things when we are supposed to? I don't know I know you're not a psychologist, but what's your, because most people do come late, isn't it? I don't know. What's your
Yeah.
experience? Yeah.
I think it's a combination. It's a combination of things, and I would say it differs. Well, the reasons may differ from one practitioner to the other, but I think in some instances it's just a matter of not understanding. You know, it's just not understanding the severity of the consequences that may stem from whatever complaint or process that's being initiated. Sometimes it's a matter of convenience. For example, the one that I shared about this one other practitioner that proceeded to just pay out and sign an acknowledgement of debt as a matter of practicality. I mean, in that instance, it was just more of a common sense approach, not being really wary or appreciative of the consequences of such conduct. So I think it really is a combination of many reasons.
Yeah, but how do you balance compliance versus, because if you look at the hierarchy of needs, compliance versus hunger. Remember, someone is withholding your money and they bring a document and they say, if you sign here, we release your money, and you're looking at the hunger part, you sign, and then suddenly they now report you to HPCSA. Obviously, it doesn't seem like the powers are balanced there because, I mean, you're hungry. And you've got debt to pay.
I hear you. Look, I fully get what you mean, and that was exactly the situation with this particular practitioner, and I fully understood where she was coming from. But what I said to her was to say that, you know, in such instances, you rather not breach the regulations or do anything that may breach the regulations, because the severity of doing that may actually prolong the elevation of that hunger, if that does make sense. So you
You'll be more
you
hungry
may
a long
just
time.
prolong
Yeah.
you may prolong the hunger by not following the regulations precisely.
Yeah, I don't know. Tammy here has a question, but Tammy, you are trying to justify not doing the right thing immediately, I think. Because Tammy says, what if one loses the contact details of the insurer? Tammy save it everywhere. But anyway, it says like in an unrest or riots and you fail to report the claim to the insurer immediately, but at least you have an affidavit and case number. You see, even that affidavit, whatever you have put there, from what I understood today, you need to be very cautious of writing things. Then you report late. Do you think the insurer they will accept? They might accept, but there might be implications. But I don't know. What's your response to this one, Ebdo?
Yeah, look, that's a very practical that's a very practical question because
Yeah.
it's something that may have happened
Yeah.
in 2021, for example. In those instances, Tammy, it really is dependent on the insurer. Well, I mean, in that instance, it would be very difficult for the insurer to reject your claim on the basis that the records were destroyed. It does obviously prejudice the insurer in defending the claim where you do not have the records. But what is also it's not good, but what is a positive in those cases is that the claimant needs to prove. So if you cannot produce the records because they've been destroyed during the riots or some sort of unrest, in that instance, the claimant may find it very, very difficult to prove their case to start with. So I think that would be a very practical response to the question.
Awesome. I'm getting a lot of WhatsApps. People are wanting your number, but I think email, ne? Hebdo.
Yes,
I think email. So colleagues, I'll share the
that's more
email
convenient.
in the WhatsApp groups. That's why I was replying. So can we have obviously I know some of us are already in distress and we need help.
Yeah.
So email is better because it's also a recorded conversation versus a phone where and also availability
You
is
respond
difficult.
to emails much quicker much more quicker than the WhatsApps or telephone calls sometimes.
Yeah. Nhlangano says if a practitioner fails to renew their council registration and at the same time they fail to obtain the required compliance points, how long does the HPCSA wait to strike off the role? I'm not sure if Mto is the right person because it does not represent the HPCSA, but maybe the question is whether you can be helped when you are stricken off the role. But I mean, try to comply. Your comments on this one, Mto? I don't know if you are able to represent the
Yeah, no,
council.
you're quite right there to say that's probably more suitable for an HPCSA personnel, yes. But in terms of, I mean, I would say you try to comply as much as you can. I'm not sure if there's any part that I can respond to in relation to that question.
Yeah, maybe when you get the letter that you are being stricken off the roll.
That's no, and it can be well. I'm now talking from my experience with the legal profession specifically. The process is to be brought back onto the role is not that easy. It's quite a long process. So it's probably easier to maintain your status on the role than trying to be re-enrolled. So try to comply as much as you can, Nhlakanipho. I cannot hear you, Doc. I'm not sure if it's just me.
I was actually reporting myself that I'm having coffee.
Oh, okay.
But there's a question by Hanan saying we had a car
Okay.
accident and at the time our car was not insured. and the other person was in the wrong, and it was all reported in the police report. The insurance of the person waited for just 1 month before the 3 years period ended. They didn't give any notice, but later we were only given summons. The lawyer we went to for assistance made an agreement with the insurance company for the other guy for us to pay. It was not nice at all to be in that situation. The advocates reason that it is a small amount to go to court for 18,000. Just sharing with you something that can happen. Okay, just sharing with you some
Yeah,
time
that's
can happen to you even if you do everything correctly. And I don't know.
yeah.
What will be the
Yeah,
correct
look,
process here? Maybe Hanan says they've done everything correctly. What would it be? What would have been the best process for an uninsured person who gets involved in an incident?
yeah, so those become third-party claims. So what you would do, you are actually the one that can claim from the wrongdoer. It's not the other way around. You shouldn't be sued or be held liable rather, where you are not you are not in the wrong, because one of the requirements there would be wrongfulness, and if you've acted accordingly in the driving, you shouldn't be held liable. In fact, if your car has been damaged as a result of any fault or negligence of some sort on the part of the other driver, you have the right to sue or request or demand payment for repairs from that other driver. So I'm not sure if that does answer the question, but I think it does. And in that instance, I mean, you were being sued, and your counsel said you rather pay. I mean, there's got to be a legal basis for you to pay. You cannot just pay just because it's a smaller amount. I mean, even if it was just 10,000 or 5,000 rand, there must be some sort of legal basis. I'm not sure if that was sound legal advice, but I'm just sharing this without full sight of the
Of the issue.
documentation and the information,
Yeah. I think the
but
legal
based
counsel
on what
just
you've
said.
just relayed.
I suspect the legal person just said, "I'm gonna charge you 50,000 for going to court. These guys are asking for 18,000. Maybe just pay the 18,000, something along those lines."
Yeah,
But that's not
rather than
how.
just say see another attorney than saying the person must pay. You just let the person go see someone else who may be willing to charge them less.
No, I agree with you. So, Dr. Quinda says, what is your take on practitioners charged for fraud by the HPCSA? What is the implication of such a charge from a point of view, considering that fraud is a criminal offense? But I heard you in one of your slides, you were saying you could go through parallel processes because fraud is also an ethical issue from an HPCSA point of view. I don't know. To what's your take? You might be charged both sides, criminal and also by the council. What's your take?
That's spot on. So you, in that instance, you may have to run parallel processes because, as you've correctly pointed out, fraud is unethical conduct, and therefore HPCSA does have a jurisdiction to deal with such a complaint, and with fraud, the implications can be severe. It can be very, very severe because fraud requires intention. So you intentionally defrauded a patient, and therefore the implications for that can be very, very, very severe. And it doesn't. To go back to my earlier point, at the very same time, it would be quite correct for criminal proceedings to unfold in that particular instance. Yeah.
Awesome. I'm gonna call you brother Mto. So Tabi is saying, what is your opinion that we doctors must pay a council every year, but this council is not protecting us? I see this in a lot of groups, WhatsApp groups and Facebook groups. As doctors, maybe we have a belief that the council is there to protect us, but from what I see, in how they write their statements, they are protecting the society from us and preserving or protecting the profession, not necessarily the doctor himself. I don't know. That's where I'm at with the HPCSA and my understanding. What your take? Because you see,
Yeah,
the
look,
problem the paying
I
is to pay someone who doesn't protect you. I think that's where Tavi is worried. Yeah.
Yeah, look, I think we share the same also in the legal profession. I think if you were to ask many lawyers, they would also share similar sentiments. But to just answer that, I think you've actually answered the question. The HPCSA is there to obviously protect the integrity of the profession in the eyes of the public. So they actually protect the integrity, the dignity, and of the profession. So they protect the public in the process, so that you as the professionals or medical professionals, you do not exploit or do wrong things, if I can just put it so plainly, or breach specific regulations to the detriment of the society, which would, in those instances, then taint the integrity and just the general impression of the medical profession in society. So I think, it is painful to pay someone to punish you, I must say.
Do I ever like a high note? So, colleagues, I know we're gonna just continue until past. So, if you are under pressure, the kids are not going to school tomorrow. I don't know. Feel free to leave. But if you are interested in the discussions, feel free to stay. The only announcement is the masterclass happening this Saturday on alopecia hair loss, and so don't miss it. But I think we're gonna continue at least for another 15 minutes and see if we can take more questions. Matthew's asking, so if you're not insured and you need mediation for a negligence case, who can you contact? How would you approach that in terms of mediation if you are not insured?
Yeah, okay. So if you do not have insurance for any of the processes that we discussed, you you are well within your rights to obviously seek legal representation. So you would need to appoint an attorney, and in that instance, you will have to finance the process or the legal process yourself, because you do not have an insurer to foot the bill in that instance.
Awesome. Colleagues are very happy, Mto, with your talk. Mwa Filimone Matungulu says, thank you so much. Felipe says, wow, what a wonderful presentation. Very clear, informative. Yeah, I thought it was
Thank you so
awesomely
much.
presented. Very informative. And Dr. Makito says, my attorney, thank you for being precise and pinpoint accuracy. Dr. Makito. He's very happy. Let me take the
Thank you.
last positive one. Moshabi says, very empowering. Almost forgot this part of practice. Yeah. Don't forget it. It's very crucial. Let's read this story then. Evening, colleagues. I was listening but couldn't sit down to view the slideshow. My question is, in case of a situation that you get summons from an older case while you were not yet insured, would your current insurer accept to represent you for such a case? Let's say it was 5 years old and you are only summoned today. Yeah. Mto?
Sure. Yeah, I must say, those are quite frequent, those kinds of situations. And to be honest, it would, one, depend on the policy itself. So what you normally find in these policies is when you take out these policies, there would ordinarily be a question to say, are you aware of any instance or incident that has happened in the past? 5 years is a bit longer, but they would say 3 years, for example, that may give rise to litigation or a civil case. Then, in that instance, you would obviously need to tell your insurer, say, well, if there is that you are aware of, you say yes. If not, you say no. And if you say yes, then there will need to be, your insurer may say that we will cover that specific incident if it does come through. Well, if you do get sued for that incident, but 5 years is a bit long, Doc, and I think in that instance, depending on the facts of the case, my suspicion, just without having sight of the details of the matter and the documents, there is a possibility that that case may have prescribed in any event. So I think my advice there would be to say, check with your insurer whether they are in a position to cover you for that particular case. If not, seek legal advice, because it could very well be a case that is prescribed. Yeah. So yeah, that would be my response to
Advice.
that.
Yeah. Thank you, Mto. Joy is asking, has it happened before where the court can order a practitioner to provide access to their electronic medical record system? The whole system. I wonder what would they be looking for? But that the courts, it's possible. Mto?
Joy, it would be very, very bizarre if the court specifically requires electronic medical records. There is no legal prescription that stipulate the format of record keeping. So, well, obviously nowadays it may be very much convenient for you guys to have electronic systems in order, but and also, unless if in your defense or your response, you said, or you relied on your electronic medical record system, then the court may say that it requires access to, I would say, specifically for that patient. They cannot want to look, or rather to have access to the entire system. It cannot be, because in that instance, then you run risk of POPIA breaches, because there will be other records that relate to the other patients there. So your doctor-patient confidentiality privileges, they may be breached. But if you rely on your electronic record system, particularly for this patient, well, then in that instance, there may be a good grounds to have access to specifically that patient.
Yes, awesome. Thanks for that. So Moshabi is asking, just that I don't know which, because you have covered so many things there, which are all possible misconduct from our side, whether it's charged as a crime. But he says, if the misconduct occurs while employed by the state, is the approach still the same, or the case would involve the employer? Just that I don't remember which one. It's just a basic misconduct at work, or I know if it's litigation, usually they will charge the
So
MEC. They would even go for the employee in the state. But I don't know what you want to say, because I'm not sure the misconduct Moshabi is referring to specifically. Yeah.
Look, Doc, when it comes to misconduct, and maybe I think Moshabi there is being specific with misconduct because I mean, when it comes to the issues of misconduct, you may obviously be reported, you as a practitioner, to the HPCSA for misconduct. But for negligence, in the litigation sense, there you would your employer, being the MEC, would be cited in the papers. That's how it would ordinarily play out.
I was saying Dr. Munyadziwa is back, and it's based on the previous question to say
I
what.
cannot hear you, Doc.
Yes, can you hear me now? Can you hear me now?
Yes, I can hear you. Yes, yeah.
Oh, okay. So there's a question you can check on the screen as well,
Yes, I
if you
can.
can see it. It says, what is your take on charges of fraud for unprofessional conduct in terms of the burden of proof? I think now it's a lawyer to a lawyer question. Ne? It's attorney to attorney.
Yeah.
Yeah.
Yeah. Yeah. This one is, I think I did say earlier on to say it normally comes down to circumstantial evidence, and I think an attorney would understand that better than the medical practitioners. Circumstantial evidence in the sense that um, your financial documentation becomes quite critical in cases of fraud. But also, I mean, nowadays it can, there are so many ways that investigators can go about in investigating fraud. And I think admissibility of that evidence should be allowed in court, and it should stand. That's my take. That really is my take. And you, as a medical practitioner, you need to then be able to rebut whatever, or be able to defend or provide explanations to whatever has been produced. So I do not really see any difficulties when it comes to the documentation that's being provided as evidence to prove fraud in medical misconduct, or charges rather.
Thank you. Colleagues, we're going to take the last two questions. Edward, it's good to hear from you. I haven't heard from you in a while. I'm so happy to connect with you as always. Edward says, how should one approach joint minutes and medical expense recommendations in litigation cases when the plaintiff's proposed costs appear to be unrealistic? So how do you coordinate this process?
Yeah. So, Edward, when you deal with joint minutes, you would require someone of a similar expertise to to compile the joint minute, which can obviously be a very good thing for your case, because you've got someone who is not yourself, because if you want to, well, your objectivity and impartiality is going to be clouded if the matter relates to you directly. So you rather find someone with similar expertise as yourself to assist in that process of compiling joint minute. Then when it comes to medical expenses, so for that, Edward, the certain legal requirements. So the plaintiff they need to prove, they produce proof, medical invoices, medical vouchers, and they need to produce proof that they did pay. So proof of payment for each and every invoice or voucher they, unless those two requirements have been met, the plaintiff is not entitled to claim for the expenses that they cannot prove those two requirements for.
Yeah, no, thanks, Mto, for that. Colleagues, just to really appreciate you for staying with us until this time. I mean, there's 400 plus of you. You give me so much energy and courage. Mto, thank you so much for such a detailed presentation. And I really, really, really want to appreciate you for making time to come and connect with us. And I see that we have lost Umto. I think you could pick up, colleagues, that the network was failing him. But I'm hopeful that he will come back, maybe to take one of those many topics and just look into it in a little bit of detail so that we can engage and we can get empowered. I really enjoyed his talk. We will share the email via the WhatsApp groups. And let me post the WhatsApp group link. If you are not in the CCP membership WhatsApp group, please join one of those WhatsApp groups, and then we will share some of the updates in that space. On that note, may I wish you an awesome Heritage Day or Bride Day. I know the Jewish people as well have a celebration of some sort, so may I wish you well as well, even if I'm not pronouncing what it is, but it's just to appreciate the diversity that we have. But here on the platform, we are one with one mission, which is to improve patient care. Colleagues, see you on Thursday when we deal with TB from a pathologist view, looking at the lymph nodes, and that not all things that look like TB are TB. Night, colleagues. Blessings to you and your families.
In today's fast-paced world, keeping up with the latest medical knowledge can be a challenge, especially for healthcare workers striving to provide the best care possible. Introducing the Clinical Care Platform, a proudly South African, wholly owned online subscription edutech company built for healthcare professionals. Our mission is simple: to improve patient care by increasing access to high-quality, evidence-based educational resources, anywhere, anytime. With our membership subscription, you gain unlimited access to a growing library of over 155 CPD-accredited courses, weekly micro-lessons, and 10% discount on paid e-learning courses, all curated to align with local and global guidelines. Join live webinars, over 160 sessions and counting, earn CPD points on your schedule, and download key clinical resources, including templates, research reports, and practice guidelines. Subscribe, get educated, earn CPD points. With the Clinical Care Platform, lifelong learning is just a click away.
Missed our latest webinar? No worries. We know life gets busy, but your professional development shouldn't have to wait. That's why we've created webinar micro lessons. Short, focused recaps of our full sessions designed to help you catch up quickly and still earn your CPD points. These bite-sized lessons are available exclusively to active subscribed members. So even if you miss a live session, you never miss out on the knowledge or the CPD points. Not subscribed yet? Now's the perfect time to join. Get access to all future webinars, every micro lesson and more. Visit www.clinicalcareplatform.com to sign up.
My name is Dr. White. I'm an independent practitioner and I'm here to share about my experience with CCP. I was introduced into a new and dynamic way of learning. The sessions were interactive and practical. The educators and instructors were easy to approach, easy to ask questions, making the whole experience much more enjoyable. In 2024, I enrolled into the HIV Diploma Preparatory Program, and I am now proud to announce that I have attained the diploma in HIV management. And not only just that, I passed with a distinction with the help of this amazing platform. I'm just here today to express my deep appreciation for the effort and the time that has been invested in preparing these learning sessions from us. You sacrifice time away from your families after long work days to give 1-hour sessions, sometimes 2-hour sessions, and the time that you spend preparing for them as well. You are working towards creating a generation of knowledgeable doctors and specialists, not only in South Africa, but all over the world. The skills that we gain from tuning into your sessions, sometimes attending the live sessions, have also improved patient care and patient outcomes and have been a big contributor. Your work is extraordinary, and I'm here to express our gratitude as your receivers. And I pray that you continue to receive the strength to continue and carry this mission forward.
Because they are the ones that clip, the ones that have the end that clips. You don't want that. It's a lot more difficult. Yes, it locks. It's a lot more difficult because now the procedure depends on you separating these two, putting them back together and separating them again. You want that process to be as seamless as possible. So you need a 10cc syringe, that's sterile. The black needle is 22 gauge, and they need to be at least 30 millimeters. So these are 5 or 25. This is 32. This is 32 millimeters. So you need to ensure that you have the correct level.
But the weight master, like I said earlier, is difficult to biopsy. It's harder, so you can say we might not be seeing a lot of cells there. But this would be sufficient in this particular context. Then the reports will become as like a spindle cell lesion, formal core biopsy would be advised, because it's difficult on cytology to actually just tell in what cases what is the type of the spindle cell lesion, especially if you don't have access to ancillary testing.
Yeah, this one I'm seeing is like VCP malaria parasites.
It looks like malaria parasites.
Yeah.
Yeah, those are spindle cells of the mass.
Is it? Yeah, the tip.
Yes. Okay.